A witness was asked if they knew whether this woman was pregnant last year. What a day. This was the final day of the trial, and originally I couldn't find a full version, so if that's mentioned in my notes and I accidentally mention it, that's why, but I've added notes because I did find a full version, and we can go through the full final day, including what happened after. A forensic toxicologist is up for the defense, and they talk of their credentials. Prosecution questions him and simply doesn't think he is qualified because he doesn't know what the rules are for testing or collection in the state where this incident occurs. But the judge does qualify him. Now, to be fair, he has testified in multiple states and even countries. It is very strong credentials. I must stress that. His credentials appear strong, at least face value. He says he looks at the data, not just the results. Nationwide, everyone uses the same tubes to collect blood. The preservative is imperfect, but it will help keep levels the same as when you collected them because as soon as you take something out of the body, it begins degrading. You want to be careful when it comes to contamination from the needle because it wouldn't take much to change results. And he says this repeatedly, and I need to make this very clear. The vial needs to be fully inverted 8 to 11 times according to manufacturer standards. The defense takes the pen and goes, like, is that enough? And they say no. If it isn't mixed right, it might give a higher alcohol result due to fermentation. Fermentation can make the alcohol content go up. If you put it in a refrigerator, that can also slow it down. He said acetone would be there due to fermentation. The expert's saying he doesn't think her blood alcohol content is accurate. Now, her blood alcohol content is very important for this case, so prosecution is obviously going to cross. Can acetone appear in the body naturally? And the witness says he isn't aware, but the body would have to get rid of it because it is toxic. I already know the answer to this. We'll get more to it later, but this expert, I immediately don't like him after that point. He reviewed the toxicology footage, but didn't see the video of the blood draw itself, so he didn't actually get to see whether they shook it enough. The collection is done the same nationwide. Testing can be done differently, and like some California counties have like a more advanced version. He says how often fermentation occurs varies, says you can't know the amount of air after fermentation occurs. Defense says her blood alcohol increased from the time it was taken until the time of testing. Experts said there is a microbe that can actually speed up fermentation even more when mixed with the preservative. He doesn't know how much the defendant had to drink that day. He said acetone and isopropanol does not occur naturally in the body. Defense is back up. You want to be as accurate as possible. The blood should be immediately refrigerated and tested as soon as possible. Just because a county violates, there are still national standards. Prosecution is back up. They're asking about the standards. The defense tries to object, but it's overruled because the defense started talking about standards. The witness says that in the Michigan standards form that he's holding, it says to shake it enough times. The witness was paid $5,000 retainer. Defense is back up and said the vial manufacturer says 8 to 11, and that is what is required. Next up is a witness we saw previously for the prosecution talking to the prosecution. This is the woman that tested the blood. She said there weren't issues with the blood. There was no excess clotting, so in her opinion, the preservative was distributed. The lab policy is that they accept all the samples, including unrefrigerated ones, in a reasonable amount of time. There isn't a time frame for what is reasonable. This testing was extremely fast for what blood alcohol testing normally is, and there is no isopropanol found in the sample. It detected background noise. The acetone was slightly larger, but still insignificant. And acetone can appear in the body, for example, with diabetics, and the keto diet will increase acetone. I know this because I went into ketosis and did that diet with a friend in college. So as soon as the acetone talk started, I was like, I'm going to wait for an expert, but I'm pretty sure I remember that being something I read about. Binge drinking will also increase acetone in the body. This was kind of like, it was mentioned, not highlighted, but binge drinking will also increase acetone in the body. Not great for her. The highest amount of alcohol that this witness ever known to be produced in a study trying to produce alcohol from blood was 0.7 after 5 days. If there was fermentation, there would have been a sound, and possibly it would shoot out due to pressure. Now, the defense comes back up for a cross. The witness explains she did not see large clotting, that she had seen anything. She had seen improperly done samples before, but she didn't notice any clotting in the sample. The defense is focusing on her saying excess clotting and kind of ignoring the fact she said there was no clotting. A small amount of acetone in your blood is natural and fine. She has a study with her today that it's naturally occurring. Defense doesn't ask to see it. I think that says it all, to be honest. I think that puts it to bed. It can occur when you're pregnant or have high levels of stress. Defense asks if she knew that the defendant wasn't pregnant on the day of the incident, and she says she doesn't know the client. I don't know. Again, this is one of those things where, like, who is this for? Is this supposed to help the jury? She explains all the requirements that exist to cause fermentation. He asks if they test for if it was fermented. She explains the signs of fermentation, and the judge has to stop the defense from trying to stop her answer. That happens a few times today. They go back over the graphs, redirect. The acetone level is brought up again with how small it is. They don't even report it because it's so small. Defense says she is who decides. The defense asks the witness if she is who decides who reports it or not. She tries to answer, and the defense again tries to stop her and says a yes or no question, and the judge says, no, it isn't yes or no, and she explains that it's below the calibration curve, so they can't quantify and report it. The hospitals might test for different reasons, so they might test different levels, but they can't quantify and report it. Next up is a man who sells alcoholic beverages, and this is where the defense falls apart. And the defense wants to have a very important sidebar. But we're back to the questioning. This man was working the day of the accident at Fermi 3. They open at 9 o'clock. He made a sale to the defendant, and he can reprint receipts. And he did reprint one from that day, and it's an exhibit, and they show it. And the time on it is 9:01 a.m. Just 1 minute after the witness said that they opened. The defendant, according to this, was buying alcohol a minute after the official open. What did she buy? 4 packs of 187 milliliters of Stutter Home Pinot Grigio and a bottle of Souverain Cabernet bottle of wine, 750 milliliter. Now, to put this into perspective, that full bottle of wine is half of a Sarah Boone bottle, but she also has 4 of the 187 milliliters. Defense is up. It's usual for people to buy stuff when they open, yeah. And she remembers a client and she didn't appear drunk, yeah. And it was lawful time to buy alcohol, yeah. And the witness doesn't know when she consumed it, yeah. And she wasn't drinking it in the parking lot. There weren't cameras at the time. Prosecution has another witness. It's a rebuttal witness, a deputy. So when they were removing the crash recording device from the vehicle, if you haven't watched previous days, that's discussed, there was another discovery. Now, at this point, the defense says that this discovery should have been brought up in the case in chief. And the prosecution says the defense is saying she had 1 bottle of wine, 1 glass of wine. She had 1 glass of wine, and through a process, turned that into a 0.18 blood alcohol content. This is to rebut that position. And what they found was a 187 milliliter bottle of Stutter Home Chardonnay in the center console. To be clear, the Stutter Home, the mini bottles from before, were not Chardonnay, so this is different than what was purchased on the day. That's not a good look. So the defense is up. The witness doesn't know when the defendant drank it. The witness has heard of recyclables. He doesn't know if the witness recycles. He's never seen a video of the defendant drinking in her car. He says people have recyclables in their car all the time. They found no full bottles of wine in the home. Defense is up. Search warrant was 2 days later. I think. Hold up. Did I get this out of order? I might have got this out of order. Give me 1 second. Give me 1 second. It might be slightly out of order, but it's fine. They also found... I think this is out of order. I hope I didn't screw it up too bad. Okay, so the search warrant was done in the home 2 days later. The defendant was in jail those 2 days. Okay. I might have accidentally written over part of this. Let me explain. Basically, and if it comes up later, we'll fix it. Oh, here it is. Next up is the detective for the prosecution. He's new, so they go through his experience. The search warrant included looking for alcohol because they knew she purchased some. They found small bottles all empty in the kitchen trash can and some empty Fireball as well. So this is where I had to go. So this is where the reason it's messed up is because I had to go back and fix this after I couldn't find the full video. So essentially what happened is they found the bottles mentioned in her home. They found no full bottles of wine in the home. Search warrant was 2 days later, though. Defendant was in jail those 2 days. He doesn't know when the bottles were drank. Her husband was there during the search. He doesn't know what the husband drank. You can't say who drank those bottles. Defense asked if they compared the lot numbers from the wine in the car to the lot numbers from the party store. Prosecution objects, withdrawn. Tries another question, suggests the husband might have drank it. Objection, withdrawn. So basically, that I would just want to be clear since I know they got mixed up. Basically, they found what they believe is the wine bottles from the store empty in her home, which is important, very important that there's empty wine bottles. And the defense is like, well, you don't know who drank it. We'll get there. We'll get there. Next up is a sergeant on the stand. He's the one who executed the search warrant and found the DVR system in the defendant's home. He has previously been up. He got footage from inside the home as well, and this was also timestamped 1 hour behind like the others. Again, defense wants to see it played to the jury before agreeing to accept it, which is so dumb. So they have the video up, showing a kitchen. 9:24 a.m. Remember, 9:24 a.m., the crash is about 3 p.m. We know she was at the store getting alcohol at 9:01 a.m. The defendant is walking around. I would call it stumbling. The defense would probably call it neuropathy. And she's stumbling out of the kitchen, holding a wine bottle, leaving the kitchen. The next video is 10:24 a.m. The defendant is walking around with what looks like an empty wine bottle into the kitchen and leaving without it. Next is 10:45 a.m., holding what looks like another wine bottle while entering the kitchen and then leaving without it. Next is 12:35 p.m., so this would be, I believe, after she had the single glass of wine with her friends. She's leaving the kitchen and appears to be holding a wine bottle. Next one is, or that might be shortly before she left to see friends. I'm not sure the exact time. But the next one is 2:10 p.m. This time she's leaving the kitchen with a glass of wine. The next one is 2:31 p.m., about 30 minutes before the crash. She enters the kitchen with an empty bottle of wine and then leaves with a full glass of wine. That's not good for the defense. Defense crosses up. The witness had not been in her home before. The witness had not been in her home before that date. The defendant's husband gave them the tapes. The husband didn't go through the tape with him. The defense calls it edited. And the witness explains that these are the videos from the device. They aren't edited. These are what the device had. The witness notified prosecutor's office of his findings. The defense says the witness's job is to get convictions. The prosecution objects argumentative. The judge says his job is to tell the truth. Objection sustained. Defense tries to reword, same objection. Defense backs out. Prosecution is up as explaining The way that this DVR records that the defendant had is in short video clips due to motion. So what is shown isn't edited, it is all the defendant's systems recorded. There were no alterations. The defense is back up and asking if they're showing all the videos in the system, and he said no, there are more of her just walking around. The next thing I found was the closing, but that doesn't really matter because I eventually did find everything. I have it in my notes. I shouldn't have read that part. So we have the prosecution's closing arguments, because now, I mean, we're at that point, right? They explained to the jury that there are photos they will be given that were not included to be shown in the trial. They weren't shown to the public. Neither side decided to show the interviews. Yeah, that police interview, I'm sure someone will probably FOIA it, but it was never available for us. It wasn't shown to the public. The jury gets it, though. The evidence shows the injuries are due to the defendant's operation of the vehicle. Zane and Alana Phillips died due to her actions operating the vehicle. These are not in dispute. Her willful operation of the vehicle is not in dispute. Defense objects. It is changed to the people suggest the evidence shows she's willingly operated the vehicle. The dispute is the blood alcohol concentration and the intent when she crashed. You heard from the experts about the blood draw on the test, but this is disputed. You can remember witnesses calling her drunk and smelling alcohol. He lists the witnesses. You know the blood alcohol right before what is it here? Oh. You know the blood alcohol is right because she told us. Sorry, my thought wasn't fully typed out. Then they play her talking about it being a 7 out of 10 drunk clip. They found gabapentin in her blood, and she said she took it. And you heard from the clerk at Fermi 3, that's the store. He said you saw the video inside the defendant's house. It is true she had 1 glass of wine at Vernus. Doesn't speak for the rest of the day. The drink at Vernus wasn't the first or last drink of her day. He mentions the defense's expert, explaining the requirements for OWI. She can be found guilty of second-degree murder if she knowingly created a dangerous situation. You can think about her driving to the boat club. You can think of her asking where her husband was. You can think about her crashing into the neighbor's truck. She had to know things were not right after crashing into the truck, but she continued on full speed into a 3-year-old's birthday party. This is not a typical drunk driving crash. At almost 45 miles per hour, she drove through the wall of an occupied building, knowing she was unfit to drive. She didn't know it when she got behind the wheel. She knew it when she hit her neighbor's truck. They show the image of the children who died, thankfully from before the accident. This is about a fair trial for the defendant and for the victims. They didn't have a chance. It is about justice for these 2 kids. And now we have the defense closing. The defense says he doesn't have to prove anything. Prosecution has to prove everything. Think about what the defense attorney would say to the response to the defense's rebuttal, to the prosecution's rebuttal. The defense justifies his crying in front of the mother of the victims. She was a victim too, but of the children that died. He cried in front of them. If you haven't seen it, it's disgusting. Mention how it isn't okay in cases to do that. He will go on longer for this, the normal for this defense. Sympathy for all affected. There has to be intent. If you have a heart attack and hit someone driving down the road, that isn't intent. Actions speak louder than words. He says his client doesn't have a record. She doesn't drive around committing crimes. He starts to say she went to lunch, backs up because he has more to talk about, complains they didn't put everything for the case up in case in chief. They waited for the rebuttal. Why did they bring it up if it's true and lawful only now? Fermi 3 is a corner store. She brought some household supplies and small bottles. I think that's what he said. I think he said household supplies and small bottles. So, I mean, I remember going back and listening to that. It was a little, maybe the audio I was listening to was a little hard to hear, but I guess you could call having a bottle of wine around a household supply, technically, if you always have it around for like dinner, but that's weird wording. I think that's right. I hope I didn't get that wrong. But anyway, there is nothing illegal about what she bought. They talk negative and we talk positive. She went for lunch. They say she said she had a sandwich. They said no. Check the receipt. It will show my client has a better memory. The server says defendant was sober when served. He says we know before 11, she was solid sober. After she left, solid sober. If she was drunk, she miraculously made it home. She parked her car, and that's a sign of sobriety. He complains about the video being played at the rebuttal. He says maybe she is drinking, but she isn't tripping or falling down. But we don't do maybes. The collision was out of character, so it makes him think something neurological. She's a former Commodore. Reckless intent. There is no intent to hurt anybody. It doesn't make sense. She's a former Commodore. Married. The court reporter says something about delaying things a moment, so they have to take a moment for her to do something. He says he understands what the video shows, but there's no intent. He talks about certifications and acetone when it comes to blood tests. If you want the blood pure, why wouldn't you get a breathalyzer done? Why not a urine test? The blood was drawn. You can ask for any of those videos and watch it yourself. Did she shake it or invert it more than once or twice? He suggests the phlebotomist had an attitude with him. The preservative is important because that is their case. I don't doubt the result, but how do you get it? There was something wrong with the fermentation. He wants them to look at the acetone graph and says it's big. Have they done testing with people taking acetone for effects? So now he talks about my person, which is his expert, I assume. He says his expert was professional. He was honest. He said acetone is nail polish remover. It occurs through fermentation or pollution. It shouldn't be there. If it was, it spoils the result. Alcohol has to be right on the money for this case. Where is the breathalyzer? The less tests you do, the less defense can question. She isn't in charge of it. The police is. She can't order the test. It is supposed to be refrigerated. Fermentation is a very strong animal. If things aren't done properly, they have to be found not guilty. Your decision will affect my client's life. He thanks the jury for being there. Think of what the defense would say in response to whatever the prosecution's about to say. And the prosecution rebuttal is up. It's short. Why didn't we bring that evidence earlier? That isn't how we prove drunk driving. We use blood results. He put that into question, so we had other evidence because we have a blood result. The Avernus waitress saw her a few minutes and didn't see her after she left. The bartender and officers at the scene, trained in spotting alcohol consumption, met with her. What convicts is lab results, video, injured people, and the deceased victims. The intent was sealed the moment she put that car into drive and went down the road. When she backed out, that's all it takes. If she ran over someone then, that's OWI murder. She continued on anyway. I asked you to look at everything and when finished, find her guilty on all counts. And the jury came back in about 2 hours. Guilty on all charges. You can see people in the audience crying. She will be sentenced May 15th. She is remanded pending sentencing. That's a good call. We'll hear why in a moment. Father said he is going to the child's graves to tell them how it went. He will never find peace. The evidence clearly shows what she did. The defense lawyer was spoken to. He said the evidence came out today wasn't a surprise. He'd seen it. He said it was up to the jury to decide if it showed someone who was at 0.18 blood alcohol. He said it was that the video was edited and unreliable. He said he lost 8 out of his 10 motions, but will file an appeal. He didn't expect such a fast verdict, less than 2 hours. He worries the jury decided before deliberation. He claims some evidence was unlawfully obtained. Remember, he's claiming that all the surveillance footage, and that would probably, I believe, with a search warrant, also include possibly her, the bottles in her trash and all that all was legally obtained. That's what his claim is. Unconstitutionally attained. He said this was a one-sided case and it would be a conviction no matter what. They weren't going to talk to the jury. He doesn't think the jury was happy to deliver the verdict. His client knew going in the jury and community is tainted. He said with two murder charges, you might as well give her life. She was out on bond and people told her that at her age, just leave, but she faced up to it, which to me means that remanding her was a good call. And yeah, it pretty much at her age will be life. I know this is rather quick. I probably should have edited the part where I got confused, but I'm trying to do this quickly because I have other things I want to cover for my other channel, and I had to struggle to find all the footage for today. Eventually I found a full video after I found all the pieces. What luck. So I had to go through that and make sure I didn't miss anything. There is another case that I found. I'm not doing a video on it today But I do have it. I'm interested to see how it goes. It's interesting. It is a pro se January 6th defendant asking for sanctions because he claims he was personally told he would be able to keep certain files by Donald Trump's pick for U.S. attorney. So basically, he's claiming that he was lied to by the Trump administration when it comes to like evidence of his case he has to turn back over. That of course doesn't have a result yet, but I thought it was interesting enough. I was going to do a video on like his explanation of what happened in the meeting and his framing of it. I was going to do that. He's been calling for a lot of sanctions, and it's pro se, so pro se always means things are interesting. But I might wait for that to kind of finish and then cover it at the end. I have I saved some of the documents, so I just have that up, and I think that's it for the day. It's probably the only video I'll make on this channel for the day. Hopefully you enjoyed it and got you up to speed. I'm sorry it took so long. I had to find all the pieces, wait for it to be put out. Obviously, I'm not going to be number one to put out the information fast for this one. This is just a case I came across and I found interesting and thought maybe others would too. Can't believe they asked that witness if they knew whether the defendant was pregnant last year. What was the point of that? Were they trying to say, oh yeah, definitely not at her age or something and try to get them in trouble? I don't know. I thought the defense was bad.